All right, another matter, that has also been generating reactions is the matter of the fact that the Supreme Court said it cannot admit the fresh evidence in terms of receiving that evidence put forward by the PDP presidential candidate with regards to the Chicago State University certificate brought forward by him to the courts. And that is raising questions as to why the Supreme Court did not receive that evidence, so to speak. If you could just clarify that for our viewers to better understand.
Right. The lawyers who sponsored that issue of admitting fresh evidence, I want to, with maximum respect to all of them, because many of them are my seniors at the inner bar, both at the outer bar and the inner bar. And they are people that I so much respect. They are leaders of the bar, excellent leaders of the bar in their own right. They are not only my superiors, many of them were my tutors when it comes to the issue of law. However, in this particular instance, it is the same law that all of us read. And no matter the fact that, okay, we belong to the different divides in this particular election petition, I want it to be clearly stated that they were not, I'm sorry to say this, they were not being honest to Nigerians on this particular issue. All of us know the requirements of the law when it comes to admitting fresh evidence at the appellate level. One, which is most important, is that the fact that you are agitating should be admitted with respect to a fresh evidence must have been pleaded in your petition, must have been pleaded in your statement of claim, were it to be an ordinary civil matter. Pleading is the soul of litigation. That particular statement of the law, as I've put it across, is well known and established, and it is a point that none of the senior advocates or any lawyer involved in these two election appeals can controvert. What we say that pleading is the soul of litigation is a fundamental principle. What you did not plead, a case you did not make at the trial, what you did not allege at the trial, you cannot give evidence of it, even at the trial level, not to now talk of giving evidence of it on appeal. In the election petition filed by His Excellency Alhaji Atiku Abubakar, paragraph 146 of that petition is the only paragraph, is the only statement where it was tacitly stated that Asiwaju Bola Ahmed Tinubu was not qualified to contest that particular election as at the time of the election. And why? That paragraph stated that because it did not meet the constitutional threshold. Now, when we responded to that particular fact, we said Asiwaju Bola Ahmed Tinubu was qualified to contest the election at the time of the election because he met the constitutional threshold. That is the end of that pleading. In law, that is the end of that pleading. Were it to be that they wanted to make a case that he did not go to Chicago State University, or that he did not graduate from Chicago State University, or that the certificate that he brought forward that he submitted was not obtained from Chicago State University, they were supposed to have stated all these facts expressly. They must be documented. You don't plead piecemeal in litigation. You don't advance your cause half-heartedly, haphazardly in litigation. You have to front-load your facts. The other party will know what you are alleging. For instance, if I say your Zubakun did not go to university, or is not constitutionally qualified to contest an election, the next question somebody will ask is, why did you say so? Is it that he was not he's not a Nigerian citizen, or that he did not, he's not up to maybe 45 years of age as may be required by the Constitution, or that he was not sponsored by a political, somebody who will want to know. No, you don't plead by allowing or putting it across to your opponent to now be asking questions. Why are you saying I'm not qualified? No, that is not the procedure. They all know that the procedure is that you must plead the facts expressly, so the other party will know what exactly you are alleging and will be able to controvert you. Where you plead that way, and you want the court to take an evidence on an unpleaded fact, the law is that evidence adduced in support of an unpleaded fact goes to no issue. It must be disregarded. There are 1 million authorities, decisions of courts on that issue. That is one. Two is that evidence that you want to adduce on appeal, that particular evidence must be one that with reasonable diligence couldn't have been obtained, couldn't have been discovered by you at the trial court. Let me ask you this question. Can they say in all honesty that evidence they wanted to adduce at the Supreme Court couldn't have been discovered with due diligence, with reasonable diligence? No, not at all. The Chicago State University was not established last month. Chicago State University had always been in existence. The fact that Asiwaju Bola Ahmed Tinubu attended or did not attend that particular university had been a point raised way back in 1999, 2000, thereabout. And evidence was produced showing that this man couldn't have had all these A scores in this university if he did not attend this university. If you are saying that he forged the certificate, where did you say it in your petition that this man forged this certificate? Now, forgery is a criminal allegation. You don't adduce evidence of forgery without pleading it. I must have accused you of something so that you will be able to defend it before I can say I want to prove that particular allegation. Where there is no allegation, there cannot be a proof, for God's sake. Now, now insisting that this particular line of evidence must be admitted by the Supreme Court, are they saying that the Supreme Court should jettison all established principles of law that have been consecrated in many decisions of the court because they wanted to appease some section, some mob that have been mobilized by a particular politician or a number of politicians to see things contrary to what is in accordance with reason? Are they saying that we must repudiate the position of the law, not only established by the Nigerian Constitution or the cases decided by all courts in Nigeria? These are principles that we took from the English common law. And once we are talking about English common law, we are not talking about Nigeria or a few countries in Africa. We are talking about the Commonwealth, many countries all over the world. So it is the same in the United States that facts that you are going to adduce evidence on must be pleaded. It is the same thing in the United Kingdom. Go to Australia. Yes, we are citing Australian cases. We are citing Ghanaian cases in the Nigerian court, interpreting this. Even Indian cases, foreign cases are equally recognized by our courts, though they are not binding. Where they are consistent with the interpretation of our law, will be given recognition by our courts.